It's not intended as disrespectful to say that the word achievement is too permanent a word, too permanent a concept in the context of lawyers and their work, whether individuals or collectively. Instead, what is needed is an understanding of the need for permanent vigilance. Achievements and victories can prove to be illusory. With my own good fortune many years ago to jump ship and escape the shackles of an English education and go to live and work in another country at a time of enormous social, political struggle, the United States, through the 1960s, a revolutionary struggle, the civil rights movement, and to have the chance to observe and write and see the different component contributions to a political revolution, and could observe that there were contributions by lawyers, not the most far-reaching activists, but played their part. And so in the South, there would be lawyers, no office, no resources, not those kind of lawyers, who would go from town to town to be there to encourage, to support, to argue for voter registration, and would themselves, more often than not, be arrested. And I thought that to be a lawyer could be a way of becoming a tool for revolutionary change. In 1968, when I thought to do that, Enoch Powell made his Rivers of Blood speech in England. A vicious, savage vomiting of racist rhetoric. And I hadn't understood my ignorance of those strands in our country. I hadn't understood, I hadn't known, and thought that it would be a hypocrisy to become a lawyer in a different country if this is what my country could be like. So I came back here in 1970, did law, studied law, joined a very small civil liberties firm. I don't know, was it the only one? I'm not sure. And trying to understand in the course of the work we did, what were the differences and what was the same as this struggle in the United States and the struggles here. There was no constitution here. I had not realized the possibility of doing constitutional law here. And the struggle, manifestly the same, but manifestly different. That the grassroots movements fighting for change would often be fighting as defendants in court. The tables would be turned. So attacks on the West Indian restaurant in Notting Hill, repeatedly targeted by the police, the Mangrove. The trial of the protesters at that treatment turned into a battle for civil rights in this country, and the same with those members of the Asian community who defended against racist attacks when the police would do nothing, were themselves arrested. Their battles became a battle for equality and rights and protection, and drawing on the common law, concepts of self-defense, universal concepts, self-defense and necessity, and acquittals by juries from the communities from which they came, fighting for juries that reflected communities from which they came. And so what was missing had nevertheless been assembled through social movements, understanding, intelligent strategizing. But what was missing was universal to both the United States and here. And what was missing was what the United Nations' magnificent declarations and conventions at the end of World War II had not understood. The United Nations, as opposed to United Peoples, retained the concept of nation-states policing themselves. And for a nation-state worldwide to determine in human rights who was human and who had rights. And combined with that fallacy in the decades that have followed, a parallel fallacy, concept of exceptionalism, that there are crimes so dreadful or accused people so undeserving of justice that there should be exceptions to how they were treated, how they are treated by society. And that was the experience of Irish men and women in our society for decades, the experience of young black men and women in our society. And at the end of one decade, end of the 1980s into 91, when it was realized after years of struggle that men and women had been buried alive in our prisons in this country, it was a deep shock. And it led to an understanding of change needed in the criminal justice system, as well as a difference of understanding that could play its part. It could play its part in a readjustment, a recalibration of trust for a suspect community that had been treated as suspect to be able to think that there could be justice. There could be justice. Made its contribution to a mindset that there could be negotiation, there could be peace, and there could ultimately be a constitutional resolution of the conflict in the north of Ireland. And those lessons about exceptionalism and no exclusion from the rights that all should enjoy felt like a victory, but that was illusory, because within a very few years, soon after 9/11, all of the same attitudes of thought came back in force. Men detained indefinitely without trial, our government arguing for the use of evidence that came from torture, the concept that you could have secret courts and not tell them the gist of what was alleged against them, and our House of Lords, after years, magnificently pulled back the rule of law and said, Lord Bingham and the House of Lords judges, what we have to fear is not terrorism, but laws like these. A and others, number one. A and others, number two. A and others in the European Court. We established the rule of law, but it is never permanent. It is never something that one can think is for all time. And so, even within years, the hideous events in Syria have caused again the concept of there are people who should not be accorded the same absolute protections as others. And so there are women and children, British women and children, indefinitely detained without accusation, without trial, who cannot come back to this country. And there are moves to reduce the capacity to protest now. And so what we learn is that there is a need always. We have inquiries after the event, years after, to find why men and women were wrongly convicted, to find why we were complicit in taking people to Guantanamo, to find why undercover police infiltrated those protest movements in the past. But they do not teach us that lesson, to learn from our history. And so I've taken too long, I'm sorry. But there was an activist in the civil rights movement in the US, Howard Zinn, who said, you can't be neutral on a moving train. If a train's going in the wrong direction, you can't be neutral. And as lawyers, and we're on a train, if we think it's going in the wrong direction, we're not just passengers. As lawyers, we do have tools that could affect where the train is going. And so I believe we are forever on a moving train. Forever the gains can be subverted and minimized and changed. There's always that imperative, and we should understand it. But if you think that nothing I have said is gender-directed or does not acknowledge we're here as women, then that may be right, but that is the point. We're all together on the train.